to begin to deeply address some of the needs that are happening in the Harris County Jail specifically. I also think that system of advocacy is something that all other sectors have wrap this type of service around jail health. So I'm here to support all the other advocates that are trying to improve the emotional, mental, physical well-being of our inmates, as well as asking you to build statutory standards of care around advocacy and case management in jail health. Thank you.
Trinidad Castillo.
I'm honored here to be with Reverend Griffin as well. I am a certified teacher for Houston, Texas, and this is my first time here, so I'm happy that I'm here. Um, I'm here also I have a son that's been incarcerated. He suffered from mental illness, and my concern is that when parents do not have, my son's never been in trouble a day in his life. My son's civil rights were violated, not to mention that my son suffers from mental illness. And I'm sorry, it's very emotional for me to talk about it, but the thing is that I wish there was some kind of help that families can get when they cannot afford an attorney, because I feel in my heart that the attorneys that are appointed by the state, they don't care. And when my son was arrested, he was only 16. They arrested him under somebody else's profile. And instead of taking him to juvenile, they took him to Harris County. He tried to take his life. I'm so sorry, but it's very hard for me. I apologize. So every day I have to live, pray to God that he doesn't take his life. But thank God for the National Coalition of Justice and Reverend Griffin. I just wish that there was some type of help for parents that cannot afford an attorney. My son was coerced to sign something that he told me he never did. The boys that got him in trouble are past criminals, and my son's never been in trouble. But anyway, I'm sorry. I just would. I'm sorry, I'm just shaking. But I pray that somebody looks into this. Thank you.
Thank you. We have a challenge with Lisa, either Marina or Maria Soto.
Thank you. My name is Lisa Moreira Soto. Give you a little bit of my background. I'm a legal advocate for domestic violence victims. I take that job and that role very serious because I myself am a survivor. My background in education is from Rice and St. Thomas. I've traveled the world writing on the United Nations Millennium Goal number 4, which is on child mortality. And I never thought in all my years that I would find myself in jail. When I did, I can tell you from experience to my body and what I saw, it was probably the most dehumanizing, traumatizing thing ever. No due process, no police report, and a victim that I helped at the time because her ex-husband was a DA. All the retaliation towards her now became towards me. And the public officials used the judge as well as several police officers and a sheriff to detain me unlawfully. I could not go to court. I missed 3 court dates that I was supposed to attend, not only for myself, but other victims to be there. So we're now using the prison system to not only silence victims, but to silence legal advocates. And here's the problem I see in jail. I was held in solitary confinement. I was dehumanized. I had just had a baby, and I had to use my entire weight to extract milk. I was never once given medical care, and the portion of the solitary confinement, I had to have several people like try to reach out for help because I thought I was going to die at one point in jail. I can tell you that there's probably many more people right now sitting in jail, used by personal relationships, detained in solitary, and we don't have their names currently. I know that if my parents were forced to file a missing persons report to try to locate me and an HPD officer could not find me, then there's a problem right now. And I'm asking you to please investigate how many more other advocates are sitting silenced in jail. How many more victims are coming out because their husbands are sitting in public official offices, and we are now using the jail system to silence them. It is an atrocity, and right now we need the most utter support because Epstein victims not only need the support, but us as advocates need the support. So I'm asking you please to investigate these jails. It's not just in Texas, this is throughout the entire United States. So how many more people are sitting there in silence? That's all my question is to you guys. Thank you.
Rosita Lira.
Good afternoon, morning. My name is Rosita Lira. I am a mother of 5, a grandmother of 12. I have a son who is epileptic and was recently arrested over the Christmas holidays. I myself was incarcerated for 3 weeks in Bexar County Jail, so I know firsthand how the system works and how the medical treatment of the people that are incarcerated, especially the pregnant women, as you heard previously. The inhumane treatment of these women that carry and give life. They're mothers. We treat animals better than we do pregnant mothers in Bexar County Jail. To dismiss a woman for a scheduled C-section and have her return 24 hours later without any medication, without any antibiotics, without any pain medicine, without anything to care for her baby. When you're given a towel this big that smells like dirty laundry because it's been used to wipe the floors and the toilets and used to bathe and clean your wound without care. Pregnant mothers are being mistreated, abused in the system. Their children are being turned over to their spouses who are considered the legal fathers in the state of Texas, not necessarily the biological fathers. So when they arrest someone for a crime, the whole family serves. My son was arrested at 10:30 a.m. By 3:30 p.m., I had 3 deputies with the Bexar County Sheriff's Department calling me, trying to extort me of $900 to pay through a Zelle or a Cash App, telling me that they would put my son in a diversion program. If only I would pay. Once they got confirmation, he could sign the papers and he would be released before midnight. These are the problems that need to be addressed because these are affecting the most economically disadvantaged individuals. I was recently a courtroom companion to a hearing, and the hallways were filled with misdirected youths trying to find their courtroom, trying to locate their public defender. There is so much misdirection, and a motion to revoke comes like that. My son was arrested on Christmas Eve with his friend, drunk and disorderly, okay, because he's no angel. And yet, for their cases got mixed matched, their information, their property, it took a week to recover their property. We're still going through courtroom cases, and he was arrested because he was not notified of his court case. So we need better standards when we release these inmates, so we can give justice, not just for those who have can afford an attorney, but for those who are the working class as well. Thank you for your time, and I appreciate you.
Thank you. Michelle Vela.
You want to bring trustees out? Good morning, Commissioners. Thank you for giving me the time today to speak with you and to be present today. First, I would like to introduce myself. My name is Michelle Bella. Most individuals know me as former Bexar County Constable Precinct 2. I am still a Texas police officer today. But most important today, I don't stand before you because of those titles. I stand before you today as a founder and president of the nonprofit organization that we have created, Justice Impact Institute. And in this non-organization, we have many experienced individuals that bring law enforcement, that bring legal experience, that bring veterans experience, community involvement experience, and the list goes on. We have created this organization so we can get involved with the commissioners, the board that stands before us today, where we can have an open dialogue to work with legal professors like you. Professionalisms like you. I'm sorry, I'm really thirsty because there was no drinks out there. But we definitely want to work together with you guys, form a coalition where we're able to work, meet up, have meetings, work on policies and procedure reform, look at the conditions in Bexar County, but not just in Bexar County, across Texas with our jail systems, right? But we also ask from Bexar County that we are representing Bexar County, but although at the same time that we have known that there has been several investigations into the Bexar County jail, and we also know that there has been some connections of where individuals know each other. So we would like to work on a policy with you guys where we're able to maybe look forward as to you guys assigning the investigators that would go out and investigate these local jails. So therefore there'll be transparency available, accountability, and the public would feel so much comfortable with the last remaining facts that are standing right. Because right now there's a lot of reporting of medical episodes. But in reality, the community will never know really what is happening inside those walls. And all the community is asking for, whether it's in Bexar County, Harris County, Travis County, is just to be fair, to listen to the community, to work with organizations like us who are able to come in and sit down with you, work with us who do have the experience in law enforcement, legal background, veterans, community, and so forth. And our list goes on with our organization. And so again, I extend the olive branch. Before you will have some information, it's very brief. I just pointed out a few subjects that we'd like to speak with you about, a little bit about our mission and our contact information, because we do look forward to coming next time and maybe perhaps moving forward on some kind of advancement of where we're at today. So I appreciate your time. I thank you. You guys have a great rest of the week.
Deontay Davis. Deontay Davis. As I As I told everybody up front, you've got to be here when your name is called. Hannah Reed. Hannah Reed.
Hello, my name is Hannah Reed, an activist and a legal worker on the Peruvian case. Today I'll be talking about the conditions faced by my friends, political prisoners Joy Gibson and Marcelo Reyna. Joy Gibson returned to Johnson County Jail in April 2026, where they were placed in general population. In May 2026, their funeral pod was moved to an underused male section of the jail, where there was moss growing in the toilet, mold in the ceiling and showers, and infestations of ants that bit people while they slept. On July 1st, after their federal sentencing, Gibson was moved into an infirmary cell polluted with pesticides. As they are being denied their daily inhaler, it is in violation of Texas Administrative Code 273.2 and 275.1. In the days that followed, cooperating witnesses on Gibson's case were moved into the cell with them. They are constantly in the presence of people who have agreements with the state to inform on them without an attorney present. Gibson still has state charges going forward, and this puts their state case at risk, violating Texas Administrative Code Section 271.1 and Criminal Procedure Article 2.18. Monica Larueda was returned to Johnson County custody in June 2026 and placed in administrative segregation where she faces excruciating isolation, as well as hand and leg shackles and humiliating strip searches every time she leaves her cell, including to shower and go outside, which is a violation of Rule 265.2. The UN Human Rights Standards has designated solitary confinement as a form of torture, yet Johnson County Jail uses it routinely. Marcelo Reyna has absolutely no disciplinary since being incarcerated over a year ago, yet the facility claims unjustly with zero evidence provided that she is a threat to facility security and an escape risk, which violates her right to due process under Texas Administrative Code 283.1. She has been open about her political beliefs. It is clear she is being politically persecuted. Furthermore, she was threatened by facility mental health staff with being placed naked in a suicide cell for 4 days for invoking her right to have counsel present. When mental health staff tried to interview her about her appeals after her sentencing, a violation of Texas Administrative Code 265.8. The facility has also denied her the right to privilege calls with her lawyer. On 2 occasions, June 22nd and July 8th, she was placed in a room with cameras. On July 13th and July 22nd, her lawyer meeting took place at a desk phone with a lieutenant and a sergeant present right next to the CO time clock. As seen by these examples, Johnson County continuously violates attorney-client privilege. Johnson County Jail has a history of noncompliance, a place where torture is normalized through segregation, excessive strip searches, environmental hazards, and legal privacy violations. The sheriff is also indicted on multiple crimes in this film.
Thank you. Grace Reynolds.
My name is Grace Reynolds. My husband is a former corrections officer currently detained pre-trial in Guadalupe County. Last meeting, I spoke on the abuse and neglect occurring in Guadalupe County, including allegations of sexual misconduct against inmates. Just 1 month ago, three Guadalupe County jail officers, including one corporal, were arrested on such charges. Since the last meeting, my husband has attempted to see mental health professionals. After months of waiting, he was taken to see a nurse practitioner who did not listen to his struggles, and instead of giving him a simple anxiety medication as he requested, she put him on an antidepressant. He has since requested to see medical again to no avail. When he was taken into custody, his blood pressure was mildly elevated. The doctor told him that they would be monitoring his blood pressure. 10 months later, they checked him for the second time. His blood pressure was 186 over 102. This is a hypertensive crisis. And he needed immediate medical evaluation.
They have since, 5 months later, checked his blood pressure 2 times. Guadalupe County Jail faces chronic understaffing. Yesterday, an officer told my husband that there was only 9 officers on duty, including rank. By current average population numbers, that puts the ratio at 52-1, and we all know rank isn't on the floor. A standard violation that has gone unchecked. The officer continued that just a few weeks ago, he was sitting on 99-1 ratio on his unit. A gross imbalance of the current standard ratio. 2 months ago, an officer outed my husband, telling other inmates of his former employment and his name. He was then subjected to relentless harassment, threats of violence and death that went unchecked by officers and ranking staff members. It is the job of this commission to set standards that protect incarcerated individuals, standards that uphold constitutional rights to each individual housed in Texas jails and prisons. The standards are under the floor, and the officers and sheriffs use these basement level standards to excuse laziness, abuse, neglect, and unconstitutional treatment of these individuals. The arrogance of law enforcement is highlighted in the book, How the Feds Target the Innocent, by the famed civil liberties lawyer Harvey Silverglate, in which he quotes a statistic that the average American citizen commits 3 felonies a day unwittingly. You aren't innocent, you just haven't been targeted yet. We live in a meet minimum standards era. Therefore, the standards set out by this commission must be raised to a level where these institutions and officers must strive every day to exceed them. And when they fail, they must be held accountable. This commission has a constitutional duty to protect these individuals who have had their ability to protect themselves stripped of them. These institutions hide behind brotherhood, lying to this commission about noncompliance, burying evidence with lost paper trails, the notion that inmates lie, while upholding lives of officers and using the badge as a license to marginalize and dehumanize these individuals, and mask their lack of human decency with a veil of pride for the uniform. I'm here to demand standards be raised, demand more oversight, and to demand accountability for law enforcement, corrections institutions. Thank you.
Anthony Costello.
Well, my name's Anthony, and I first started going to Bear County Jail in 1994 when I was 17 years old, and I was beat while I was stripped naked in the basement and kicked in my balls, 19th birthday. And that day, I vowed that I was going to the system. So here I am. And one thing I noticed up here is there's nobody that's ever been incarcerated, or I don't know if you have or not, but I doubt you guys are. And it's hard to make decisions if you've never been inside. So I think we need somebody on the board also that can do that. But moving on, we need your support in the jail. The conditions are horrible. I wrote to you guys the whole time I was in there. I've been going in and out of Texas jails now for the last several years to uncover constitutional violations, and now we're about to unroll the report. I've gone into Harris County, Bear County, Hidalgo County, lots of them. We've got lots of stuff to show you guys. Denial of access to law library in Bear County Jail. Time in the cell. There's no paper grievances. We have to do it on the kiosk. You can't file a lawsuit without paper grievances. You know, access to competency. I was just found incompetent and held in the state hospital for over 2 years. I had to wait a year waiting on the list, held in solitary confinement. I suffered post-traumatic stress disorder. I was denied detox medications coming into the jail. I'm a former heroin addict. I was on methadone when I went in. They're being denied. They stripped everything from us in Bear County Jail. I told Sheriff Salazar when I first went in there that I was going in there and what I was doing. I actually helped on the campaign a little bit, and he ignored me. And I guess he thought I was joking. And I told him, the things that you're doing here is going to cause this to be the #1 suicide jail in the state. And that's exactly what happened. We have no radios. We have nothing, no mail. You are stripped and put in a cell with absolutely nothing. The conditions in there are absolutely horrible. I do this for a living, and that is the worst jail I've ever seen. People locked in the cell all day long, all day. I don't understand why it takes you 5 hours to count, but That's the reason there's so many deaths in that jail. You know, you can't lock somebody in a cell and leave them there all day and not check on them. I mean, they're gonna kill themselves, there's gonna be medical emergencies you're not gonna see. I mean, it's proven that isolation causes people to be more aggressive. And by locking the entire county jail down for all those hours, that's what you're doing. You're creating a public health hazard and a public health threat. You're making already violent individuals more violent. You know, there's mold going or coming out of the vents, black mold. We're walking through sewer. They try to, before you guys show up for your visits, the whole month before that is a whole team getting ready for you guys. I mean, there's a bubble around you as you're walking through the facility. They're calling different tickets. They're coming to this, they're on their way here. They're on the walkie-talkies, they're coming this way, they're going here. And they're trying to correct problems as you're walking into the pod to hide. And the minute you guys walk out, it's all back to normal. I mean, there's plenty of Facebook posts showing this and officers coming forward. There's nurses that are scared to work there that are getting bullied into quitting. There's cadets that are quitting because they're getting bullied. There's just too many unconstitutional conditions in it, and we need you guys to investigate it. We need you guys to get somebody that has lived experience inside of there, because what's happening to the mentally ill is extreme brutal. Not just mentally ill, but everybody. What's happening in those jails, I invite any one of you guys.
Still, your time has expired.
If you want to walk in there with me, I'll go to jail with you. Let's go do it for a month.
Thank you. Lydia Leos.
Good morning, Chairman, Commissioner, Executive Director, and members of the Texas Commission and Jail Standards. My name is Lydia Leo, founder of What's Behind the Cell. I'm glad to see so many people from Burke County today. I'm glad to see Sheriff Salazar finally here with us. I submitted a petition to this commission to adopt a statewide minimum standard for family notification in case of emergencies or death. Thank you for putting it on the agenda today. This is Julian's 6th-year anniversary of being in heaven, and I thank God that I'm still able to speak for him and everybody. Every jail requires a person to provide emergency contact and next of kin information during the booking process. That information is collected because it has a purpose. When a life-threatening medical emergency occurs, that information should be used without unreasonable delay. Silence should never become part of a jail's medical response. My son Julian entered the Burke County Jail alive. During his confinement, he suffered a medical emergency. I was not notified while my son was fighting for his life. I was not notified when he required emergency Medicare. I was not notified when every minute mattered. Instead, I was notified approximately 10 hours later after my son had already died. Those 10 hours can never be returned. No mother should lose the opportunity to know her child's medical crisis. No family should receive a phone call only after it's too late. Commissioners, on one phone call cannot prevent every tragedy, but one timely phone call can preserve a family's right to know, to be present, to ask questions, and to stand beside their loved one during the most critical moments of their life. I respectfully ask this commission to establish a statewide minimum standard requiring every Texas county jail to notify a designated emergency contact or next of kin without unreasonable delay. Whenever a person in custody experiences a life-threatening medical emergency, is transported to a hospital for emergency medical treatment, or dies while in custody. Documentation creates accountability. Accountability creates transparency. Transparency builds public trust. Our loved ones do not lose their humanity because they are incarcerated. Their families do not lose the right to know. Medical notification is not simply a courtesy, it is a duty, accountability, transparency, and human dignity. Julian cannot be brought back. I respectfully ask this commission to begin the rulemaking process that Julian Dennis' death becomes a catalyst for meaningful statewide reform, and so that no other Texas family received a phone call that comes too late. 12 hours is too late. I could have sat next to my son, held his hand, told him I loved him. I could have done so many things. I'll never get that again, but I don't want that for any other family. Thank you for letting me be here today.
Jacqueline Johnson.
The reality is that it's not just impossible to ignore, it is impossible to prevent. On May 1826, this commission declared the Kent County Jail fully compliant.
Okay, so if you want to watch our meeting, we're live streaming on YouTube. If you go to the commission meeting information, there's a link on, okay, hang on, let me pull it up and make sure it's still there, but it should be. And then on the bottom right where it says where the meeting is going to be held, there should be a link to. Okay.
This timeline doesn't show compliance, it shows collapse. These deaths did not happen in isolation. Using documentation. Untreated mental things. Run out from one.
Well, everybody's at the meeting at the moment.
Your families cannot get answers when your death occurring at the hospital or treated as if they somehow fall outside of the jail's responsibility. I am asking this commission directly. What does compliance mean if 4 people die right after you say it? Because to the public, this timeline looks like oversight failed. It looks like the commission accepted the sheriff's narrative instead of confronting the.
So when you go to the link, make sure you go to live. There will be tabs at the, underneath our logo. If you go to live, it should show the one that's currently being streamed.
It shapes public trust. It signals to counties that the level of care is acceptable. And when you label a jail with ongoing deaths, missing video, and unanswered questions as compliant, you are telling the public that this level of.
I only have so much control over how YouTube works, ma'am. I'm sorry.
Oversight is a responsibility. And when oversight fails, people die.
Meredith, where you at?
Meetings. Mm-hmm.
Because he cannot distinguish reality from delusion, his probation was revoked, despite of our family's repeated pleas for treatment. Then he spent more than 18 months in Collin County Jail and active psychosis. Instead of being transferred timely to competency restoration,
It's still going
During the time
on.
he went without appropriate treatment. He spent 18 days in solitary confinement in psychosis and medicated. Only after finally receiving the medication, within 2 weeks, he was better. And that is what haunts me. The treatment that changed everything came
You want the one titled TCJS August 6th quarterly meeting.
Or even when we asked for dozens of times for help, it is policy failure. If Ian had received the right care at the right time in the right place, he likely would have never entered forensic medical health system at all. Instead, Texas now faces the consequences of thousands of stories like this. Today, the state has been ordered by federal court in a warrant case to move
Yes,
people
ma'am.
to forensic hospitals within 21 days. Then more than 1,550 Texans remain on wait list. We cannot build enough hospital beds to solve a problem. We keep creating upstream. As long as families are forced to wait until they're level and commit the crime before treatment becomes available, more people will enter the jails and more people will join the forensic wait list. And the state will continue chasing Texas instead of preventing one. Families are the first responders to serious mental illness. We see the illness first. We know when our loved ones are slipping away. Yet our voices are ignored until the criminal legal system takes over. This must change. Meaningful partnership with families must become part of standard care. Investment in community treatment, crisis response, especially crisis response, associated outpatient treatment, and early intervention, so people receive care before they enter the justice system, not after. Commissioner's Ian's story is not the exception. Thank you.
Thank you. Beverly Boone.
My name is Beverly Lee. I'm a retired licensed professional counselor who speak on behalf of working with people with mental illness, with your mental illness. I was in case management, I was working at the hospital, and also insurance companies, and I was administration of war in Hyde Hospital, I was administration of war in the insurance company, and I also worked in behavioral health quality of care and reported investigations to the Texas Department of Insurance. So I know what good mental health care is, and I also know what failure of mental health is. It's very devastating to these people. I know that, I'm repeating what my daughter just said. For more than 3 years, Ian, my precious Ian, we call him his buddy all the time, he got diagnosed with psychotic break. November 6th, 2022, I knew something was very wrong. Our family begged for help, and even as a licensed professional counselor, I can't tell you the pain that I could not get my friends. We took him to emergency room 16 times. Law enforcement, crisis services, judges, probation officers, sheriffs, mental health professionals across 3 entire counties. No one would help. Again and again, there's nothing that we can do. When as Meredith said, when his untreated psychosis led him to repeatedly send text messages to an ex-girlfriend that he had not seen in 7 years, the system couldn't find a psychiatric bed for him, but they certainly found a place for him in jail. Instead of treatment, he was placed on probation and he got out of jail after 3 nights. He was still actively psychotic when he came home and wouldn't even sleep in the house. I spent many nights going outside because I have a deck and a swing, and he would be out there, and I would have to put a mattress out there and a pillow and get up multiple times to make sure my grandson was still there. I would also sleep on my sofa so that I would be available if I heard him walking out the door. And that happened, and I stay dressed. I have my keys on me so that when I hear him leaving the door, that I can get in my car and follow him and convince him to come back home. That is not my Ian. That is not the way he operated. He spent more than a year and a half in jail with us trying to talk to someone. Please, please get him on some medication. I even told the attorney in November of 2024 what his diagnosis was. It's the only time I ever got to talk to anyone because he's so psychotic. He thought we were all part of the CIA. They did nothing. So finally he goes to court, December the 15th, 2024. We're going on 2 years here now, no medication. He loses it in jail. He's court. He's so delusional that they have to send him out of the courtroom, and his attorney stood up and told the judge, he's delusional, judge. And so they had to get a competency exam for him, which I had already told him that's what he needed.
Ms. Boone, I'm sorry, your time has expired.
I hope that you all will change the system and give these people more mental health services on an outpatient basis. That's what they need.
Jennifer Belknap?
Good morning. My name is Jennifer Belknap, and I'm here today to speak to you about my son, Dakota Belknap. Dakota ended up in a Leon County jail after being attacked on his own doorstep, and he defended himself. He entered as a pretrial detainee, presumed innocent under the law. In the middle of a severe acute mental health crisis, he was a loving son and a devoted father to 3 young children who now grow up without him. Dakota was brought into that jail needing medical protection. Instead, every single system failed him. MHMR failed Dakota by treating his evaluation like routine paperwork instead of triggering immediate life-saving care. The jail nurse and medical provider failed Dakota by failing to put proper medical precautions and suicide watch protocols in place while he was in crisis, leaving him unprotected when no medical staff was available. The jail staff failed Dakota by neglecting continuous observations and failing to perform immediate basic life-saving CPR when moments counted the most. The worst happened when they engaged in cowardly game of passing the buck. MHMR blamed the jail blamed the medical provider, the provider blamed county protocols, all to dodge legal liability. This brings us directly to the commission. There is a profound lack of regulatory leadership and oversight from the body. Right now, Commissioners Court funds the jail, but has no say-so over the oversight over medical care, because sheriffs have total authority to hire private vendors like Southern Health Partners. Allowing sheriffs continuous contract with the private companies facing nationwide lawsuits and systemic failures and preventable deaths and a complete failure of regulatory responsibility. This commission must step up and enforce real accountability over sheriffs and private medical providers. Oversight cannot just exist on paper. Dakota had no criminal record. He was attacked on his own doorstep. He was in crisis. He needed help. I ask you today to remember Dakota's name, remember his 3 children, and demonstrate leadership required to enforce accountability, ensuring no family faces a preventable tragedy because systemic liability prioritized over human life. Thank you.
Thank you. Tracy McLean.
name is Tracy McLean. I'm a registered nurse with more than 3 decades of experience. I worked at the Austin State Hospital, Travis County Jail, Correctional Corporation of America, and as a legal nurse for the OAG Tort Lift in Austin. And I also know what happens when a person doesn't receive timely access to appropriate care. My son Rob has experienced a failed system of care that repeatedly criminalized with serious mental illness. Rob was a thriving student at Morehouse College until a violent crime caused a traumatic brain injury and later schizophrenia with symptoms of anhedonia. He was a brilliant, kind, considerate young man who graduated magna cum laude in psychology, even while managing the early stages of his illness. But after his first psychotic break, our family entered a system that does not treat people like Rob. It cycles and abandons him. In the last 5 years, Rye has been arrested 10 times, detained 180 days 3 times, and pushed through 6 so-called long-term hospital stays that lasted only 3 weeks. But while jail, I learned I was not allowed to advocate for him. I knew his medications, his triggers, the past interventions that worked. And I didn't understand how a person with visual and auditory hallucinations could be held in a cell the size of a parking space for 23 hours, 24 if symptoms of his illness caused him to act out. I was here in February to tell you this story. He was released a few months later in April from Williamson County Jail after 180 days detention for criminal trespassing. The tragedy is, Rod almost received the care he needed. I was informed that 2 attempts had been made to have him transferred to a state hospital for a commitment. Both attempts were blocked, one by a Williamson County district attorney, the other by a blue-bonnet physician who felt he didn't meet criteria and basically ignored the assessments made by the competency restoration team, who knew Rod well and had spent a lot of time interacting with him and had seen him cycle in and out of jail. The restorative team knew Rod needed additional care, but were ignored. When Rod was released from Williamson County, he was still incompetent and in psychosis. The restorative team made one final attempt to give Rod some care. The plan was to transfer him to Blue Bonnet in Seguin. The forensic director of Blue Bonnet called me and assured me Rod would be transported to the facility, that he would receive an assessment from a staff physician, and that he would receive care. I was also told that I would receive updates and become part of his interdisciplinary team, but unfortunately none of that happened. I was released on April 23rd and was on my Ring camera from April 26th, agitated, angry, and disheveled. I became physically ill when I saw him and shocked knowing that I had been lied to by Blue Bonnet, that the process I'd been told to have faith in was in fact just a bunch of words to dismiss me. The only way my son will receive the care he needs and deserves is if Rider 56 is immediately implemented. I urge all the sheriffs and county elects here to demand that HSSC immediately implement Rider 56, and my sincere ask for this commission is the jails allow families who are the primary caregivers to be involved in their loved one's care while in custody. Please don't let HIPAA cut us out. It's safer for our loved ones and also for the jails. Thank you for your time.
Thank you. Patrick Walls.
I'm here to advocate for my stepson, Don Robert. My mentally ill stepson has been to jail more than 10 times in the last few years, and it's heartbreaking that each time we are horrified and relieved. There's no reason why a parent should be relieved to hear that their child is in jail, but for us, we knew that he's inside, fed, and safe. But the reality is he's not safe. He's getting worse every day that he's there untreated. There's no reason a person in a schizophrenia spectrum should be held in solitary confinement with the lights on 24/7 for 180 days with only delusions and hallucinations to keep him company. 3 times. Every time he's gone to jail, he's come out worse. He's angry because he doesn't understand why he's being punished. And every time he goes back in, he comes out angrier and more disoriented. He can't live with anyone because he reacts violently when challenged or confused. We've had to put ourselves in danger, our younger kids and grandkids in danger to take care of him because Texas won't help him. And because he's an adult, Texas won't allow us to help him either. We can't speak for him. We can't ask for information if he's been medicated, spoke to an attorney, or if he's even been evaluated. They won't even tell us when he's getting out of jail, so we find out when he shows up on our front porch, haggard and broken. Each time it's more devastating. I'm ex-military. I lived in 10 states. Y'all talk a lot of game about how great Texas is. So it's great that it's at the bottom of every category when it comes to helping the unhoused and mentally ill. It wasn't like this before. In the 90s, Texas had a more intact network for mental health care before budget cuts in the 2000s. I know y'all know about that. And I know this because I began my library career in San Antonio in the 90s, and I remember the difference. I was at Austin Public Library from 2012 to 25, and the conditions for the unhoused mentally ill are horrendous compared to what it used to be. People complain about them in the library, but we always support them because we are the only ones helping them. You have no idea how badass librarians are. We publish internal incident reports and every day read stories about psychotic breaks. Staff calls 911, asks for a mental health officer, and they tell her that there's nothing that we can do until the patron hurts himself or someone else. It's unacceptable to wait until someone is hurt before you act. Kindergarten teachers know that. Why doesn't the legislatures? It's worse and you know it. You've heard the stories, and yet you still criminalize people ahead in need of treatment. It's not too late for our son. He can live a normal life, just not in the way things are. So what is the great state of Texas going to do about it? You're okay with being on the bottom dweller compared to Massachusetts or Minnesota, who's at the top of the country and care for the mentally ill? You start with pushing Rider 56, which gives family the ability to make decisions for those who are caught in the disgusting loop of Texas jail therapy. We are regressing in 2026, and it's shameful. Take action and stop the Texas tradition of punishing people because they're sick. Get it right.
Order, when I have order in here, no cross discussions, or I'll have you removed. Nan Terry?
Good morning. I'm Nan Terry with the Justice Network of Tarrant County. Yale Investigative Reporting Lab began its Starved for Care series last year. If you Google Starved for Care, you'll find the initial series. Texas has 2 people in that initial series. Holly Barlow Austin died while in custody in Bowie County. It's horrific. A private company, LaSalle, LaSalle paid $7 million after she went blind and died in jail. Georgia Baldwin of Tarrant County died while in custody waiting for a bed in the state hospital. An autopsy indicated she had severe hypernatremia, dehydration, or a high concentration of sodium in her blood resulting from insufficient water intake. The county paid $750,000 to settle a lawsuit. Even after Baldwin's death and the payment of the settlement, Kimberly Phillips died of dehydration and starvation in Tarrant County Jail. Kimberly Phillips is in the zine that you should all have. Miranda Mills is her daughter, and she spoke at the last meeting. Her mom visited her Mills visited her mom in jail and said, her mom said, "Look at me, baby, I just need to eat." She tried to eat the food they gave her, but she couldn't keep it down. We want you as appointed board members to be aware of the issues people in jail that are starved for care and dying across the state. We don't want to be a part of the national trend. We don't want to be in the 3rd series of the Yale Investigative Reporting Lab. We want you to advocate for responsible care of detainees in our jail. During the Georgia Baldwin investigation, WFA reported 3 other deaths due to dehydration. Chief Eckert testified in a deposition that all 3 inmates had 24/7 access to water, so it's not a concern as long as we provide water to them. Later, Kimberly Phillips' death, Sheriff's Office repeated, "We supply water in the cell." These are individuals with mental illness who decompensate or get worse with incarceration and don't know to drink. They are separated from their family and friends who would tell them to drink, but the people in charge of the building where they are detained don't think that's their responsibility. Perhaps you can tell Tarrant County Sheriff's Office that is their job. We don't need any more people dying of starvation or dehydration in our county jails. I'm confused, Executive Director, by your transmittal letter of the inspection report to the sheriff, and you talk about the achievement is a direct result of your office's commitment to excellence and an example of dedication and professionalism in maintaining a safe, secure environment. The citizens of Tarrant County should be proud of your combined efforts. I, for one, as a county resident, am appalled. Did you miss the 21 deaths that are not investigated as required by the Sandra Bland Act that occurred, deaths in custody occurred in the Tarrant County Jail, not investigated by our sheriff? Did you forget the 2 jailers on trial for murder of Anthony Johnson, who died in the jail? Did you forget the 2 other jailers on long-term probation for falsifying government records regarding the death of Devontae Myers? I'm appalled. I am not proud, sir.
Thank you. Goldie Van Zant. Goldie Van Zant.
Good morning, Director Armstrong, Chairman Rowe, and Commissioners. My name is Goldie Van Zandt. I'm a proud United States Navy veteran. Today I serve as client advocate with Texas Jail Project, where I'm out from the first force families here when they have nowhere else to turn. I also come before you as someone who was married to a veteran. My partner of 40 years served this country for 20 years in the United States Navy. He came home with disabilities, struggled with mental illness and substance use disorder, and spent years cycling through the Harris County Jail. He deserved treatment. Instead, he got a jail cell. Every week, I answer calls from families who are watching the same story unfold. One of those calls came recently from the father of Nathaniel, a 31-year-old, 100% disabled veteran being held pretrial in the Walker County Jail. Nathaniel has no criminal record. He has a fractured eye socket, severe daily pain, and his vision is deteriorating. His family fears he could permanently lose his eyesight while waiting for care. His father wasn't asking for special treatment. He's asking for basic medical care. Nathaniel's story is not an exception. It is a warning. Many veterans enter our county jails carrying invisible wounds, PTSD, traumatic brain injury, depression, and substance use disorders. National injustice enforced veterans experience these conditions at a higher rate than the general population. Yet, county jails were never designed to provide the specialized, trauma-informed care they require. I want to thank this commission for creating the Veterans Reentry Search Service, VRSS jail standard. Identifying veterans is the most important first step. But identification without intervention is just another checkbox. A veteran's military service should trigger continuity of care, not a bureaucratic process. Commissioners, I urge you to collaborate meaningfully with the Texas Veterans Commission, statewide behavioral health coordinator council, the VJOs and VSAs, to build measurable standards that ensure veterans are connected to medical care, behavioral health treatment, benefits, and housing before they leave jail, not after they return. We ask our young men and women to wear this country's uniform. The least we can do is to make sure they don't lose their eyesight, their health, or their lives behind bars when they come home. Our veterans answered the call to serve Texas and this nation. Today, Texas must answer theirs. Thank you.
Thank you. Tamara Hutcherson.
Hello, Commissioners. My name is Tamara Hutcherson, and I was on the legal team for one of the defendants on the Prairieland case, in which 9 defendants were charged and convicted, ranging from 30 to 100 years in prison because of a protest outside the Prairieland Detention Center that took place on July 4th, 2025. I speak before you today to discuss the ongoing egregious and subpar conditions some of the defendants are suffering from in the Johnson County Jail as they await their state trials and appeals. This jail and its sheriff has come under immense scrutiny. Adam King, the current sheriff, was re-indicted for evidence tampering and retaliation against jail staff as he faces multiple criminal offenses for his misconduct as a public official. This jail has had a record of jail standard violations. One Prairiland defendant, Benjamin Song, received a disciplinary action after being strip searched by a female jailer. This is against Rule 265.2, which states a strip search must be conducted by jail staff of the same gender. He has been denied eyeglasses and an eye exam by medical staff, and per Rule 273.1, each jail facility shall provide medical services. Another Prairiland defendant, Megan Morris, who is a woman of trans experience, has been withheld from receiving estrogen, which is part of her gender-affirming care, and withdrawals can be a detriment to her health. Last month, Ms. Morris fell twice and blacked out, and her medical concerns were dismissed by jail medical staff, even though she presented an abnormal blood pressure and continues to have persistent pain and mobility issues in her foot due to the falls. All the Prairiland defendants have had their legal mail opened and scanned. Per Rule 291.2, privileged correspondence should only be opened and inspected for contraband. A 2023 technical assistance memo that was drafted by former Director Brandon Wood recommended county jails privileged correspondence and legal mail should not be scanned or copied due to the concerns raised regarding client-attorney privilege. If the sheriff is unfit to serve and lead in his jail by creating an unsafe working environment, then we cannot expect the jail staff to effectively fulfill their responsibilities and duties for those incarcerated. I urge you to investigate these claims further and to hold this jail accountable. Thank you.
Victoria Rogers.
Good morning, Commissioners. My name is Victoria Rogers. I am the niece of Victor Ramos. I never imagined I would have to stand before regulators to ask for something as basic as the truth about how my uncle died. My Uncle Victor was a loving, family-oriented man. He loved to dance, make people laugh, and help anyone in need. He would give you the shirt off his back because he knew what it meant to struggle. He was a son, a brother, an uncle, and he was deeply loved. To us, he was everything, but to the Tarrant County Jail, he was just another number. After spending 14 days in that jail, on January 25th, 2026, my uncle became the 5th person to die in there this year and the 78th person to die in that jail's custody since 2017. But what happened next is almost as painful as losing him. While still incarcerated, my uncle suffered a medical emergency and was rushed to the hospital, JPS. My family wasn't notified until the next morning. When we arrived, he was on life support, shackled to his bed like a slave. Then, just minutes before he died, charges against him were dismissed. At 4:32 p.m., he was technically released from custody. 9 minutes later, his shackles were removed. 5 minutes after, he was pronounced dead. 14 minutes. 14 minutes determined whether my uncle's death would be counted as an in-custody death or just disappear from the official record. I cannot accept that a paperwork decision made moments before someone dies is enough to deny my family an independent investigation. My uncle did not leave that hospital a free man. He died because he never recovered from the medical emergency that began while he was under the care and control of the Tarrant County Jail. The Sandra Bland Act was passed so that families would get the truth when someone dies in custody. That promise should never disappear because of a technicality. Our family is not asking for special treatment. We are asking for equal treatment under the law. It has now been an extended period of time, 89 days to be exact, and we have still not received a completed autopsy or been provided with any meaningful updates regarding the status. I ask this commission to count my uncle's death as an in-custody death and ensure it receives the independent investigation the Sandra Bland Act promises every family. Please don't let my uncle fall through a loophole. Because if this can happen to my family, it can happen to any family in Texas. Justice begins with telling the truth. The truth begins with counting every life. Please honor my uncle by honoring the spirit of the Sandra Bland Act. Count every life, investigate every death, and ensure no other family is denied the truth. Thank you.
Ooh, it's Lou Burnham. Lou Burnham.
Good morning, Chairman. My parenting is really bad. The first name is Juan. Good morning, everybody. My name is Juan Burnham. I served 18 years in the Texas House of Representatives. This week I served 12 hours as an inmate inspecting the Tarrant County Jail. I was charged for an alleged misdemeanor offense, and they were going to hold me overnight until the county commissioner intervened on my behalf. Contrary to the lies of the sheriff's office, PR flag, I was in for 4 different holding rooms. I complained about the filth of the first one. There was a gross looking rag covering most of the drain, trash in the drain and in the toilets, and the floors were sticky. I complained to the jailer, and her response was the cell was cleaned twice a day. I could go on, but my personal experiences and the lies that came out of the sheriff's office concerning my experience are relatively unimportant in the context of the lies concerning the deaths of people in the jail. I came to express my concerns about a comment made by your ED. It is alleged that it was said in public that the commission's job is to, quote, unquote, reduce the liability of the sheriffs. If that was said or anything close to this, we need for the assistant AG to explain the job of this commission. A quick review of the legislative intent in creating this commission would be helpful. Section 511.0086 calls for risk-based inspections. The commission apparently gave an okay review of the Tarrant County Jail shortly after there were 4 deaths in a month's time this summer. What kind of risk-based inspection was done? How can any compassionate human being be okay with conditions in the Tarrant County Jail? There are still 21 deaths in the Tarrant County Jail that have not been investigated. I believe this is a violation of the Sandra Bland Act. Mrs. Johnson is right. You should listen to her. Nan Terry is right. You should listen to her. It is clear to me that a lot of people here and in Tarrant County are not doing their jobs properly. They don't understand the job description, they don't understand legislative intent, and they probably should be replaced by the new governor. Thank you for listening. I have a copy provided to me of the legislation and provided to me by Senator West, legislative director. If any of you have not had an opportunity to review the law that creates this commission recently, you should, because you're not doing your job. Thank you for your time.
Annie Pagney.
Hello, my name is Ani, and I'm here today on behalf of Gloria Rivard, the mother of Tammy and Keenan, age 34. On April 1st of last year, Tammy was picked up by the Rosenberg Police Department, Fort Bend County. Gloria requested a CIT, Crisis Intervention Team, member several times before he was booked, as documented in the police report. He was booked for aggravated assault with a deadly weapon instead of receiving mental health intervention. Police took his medicine with him, and that was the last time Gloria saw her son alive. And 2 days later, Tammy was found dead in Richmond, Fort Bend County Jail. No explanation of how he died. Gloria was not notified by police. She found out from a third-party relative who called her to come to her house for a gathering. And the next day, before Gloria could tell her 94-year-old mother, local television stations blasted that Tammy was another Fort Bend County criminal found dead in the jail. The shock hospitalized her 94-year-old mother for weeks. No empathy, no contact from the police department. And 1 week later, Sheriff Cantu, the investigating sheriff, told Gloria on tape that he was investigating Tammy's case as a homicide, and he was immediately pulled from the case. It was given to the Texas Rangers, and the Texas Rangers refused to give any information because of Paxton. Fort Bend County jail lawyers and the Sheriff's Department say it is an ongoing investigation and prohibit her from finding out what happened to her son. And in the following weeks, the Fort Bend County's coroner's office gave Gloria several conflicting excuses of how Tammy could have died. When she demanded a second opinion in an independent autopsy, she learned Tammy's brain, spleen, and throat had been removed. That's disgusting and unacceptable. This made forensic testing impossible, and Gloria never gave authorization for this. And over 4 months later, Gloria received a statement that Tamian had died of a heart issue. He never had heart illness before, and this does not explain why 3 major organs were removed for testing. On May 6th of this year, Gloria requested Tamian's records under the Texas Public Information Act. And on May 20th, that was Fort Bend County's legal deadline to respond, and they missed it. On May 28th, Fort Bend County filed 8 days late, violating Texas Government Code 552.301B, and under 552.302, all records are now presumed public. But attorney Ken Paxton issued AJ ruling OR 2026-03-2005 anyway, letting Fort Bend County hide Tamian's entire death file. After 3 attempts to reach Paxton, he refuses to help. He is covering up for Fort Bend County Jail, the police, and the coroner. No mother should go through this devastating continuous cover-up, and we're having meetings like this, but we still have murders taking place constantly in these jails. So Gloria demands this committee give a full investigation for Tamian's death, mandatory CIT officers at these calls, ban using 552.108 to hide in-custody deaths, mandate next of kin notification within 2 hours, prohibit organ removal before family notification and authorization, stop treating mental illness as a death sentence, and find who is accountable for Tamian's death. Justice for Tamian Keenan.
Bruce Gimdu.
Good morning, Commissioners. Krish Kundu, co-founder and director of Texas Jail Project. You've heard a lot of horror stories today on custody deaths, but I have some data for you. I think you have a packet in front of you. We did our usual custody death analysis based on data from the Jail Commission. As of August 4th, there were 78 reported custody deaths. From the limited data that we currently have, we know that 79% of people who died in custody this year, this calendar year, were pre-trial, legally innocent. The actual number is most likely higher. Between 2021 and 2026, 85% of people who died were pre-trial. I hope lawmakers will pay attention to that statistics as they keep expanding pre-trial detention through so-called bail reform. On the last page, you will see we included uncounted deaths because we are deeply concerned about the erosion of the Sand of Land Act. There are 2 uncounted deaths that we know of. 74-year-old Diana Bailey, who died on February 23rd in Dallas County Jail, and 61-year-old Victor Reynolds in Tarrant County Jail. We also included outsourcing deaths. Thank you for the Jail Commission for counting those deaths now. Those are pre-trial detainees who were separated from their community and shipped out of state. 33-year-old Tevin McClendon died on April 26th after being transferred from Harris County Jail to LaSalle Corrections in Louisiana. Tevin is the 5th person since 2022 to die in Louisiana after being transferred from Texas County Jail. But the one custody death story I really want to tell you about is relevant to one of the public petitions on the agenda today. 3 people submitted a petition for a new standard to prevent over-detention. This young man's story, and I can't share his name, his family asked me to keep his name out of the story. It illustrates all types of multi-systemic failures. He struggled with mental illness, couldn't get the care he needed, landed up in Dare County Jail, where he spent 6 years pre-trial. 6 years. He was sent to the state hospital for competency restoration at least twice. When he came back from restoration, he took a plea deal, and he had over 1,000 days in jail credit when he took that plea deal. 3 weeks later, he was still in jail and attacked by another detainee on the mental health floor. He was transferred to the hospital and died a few days later. His death was ruled a homicide, but his death was not counted by this commission as a custody death because TCJS said he had time served and should be released as he lay dying in the hospital. The commission staff is well aware of this case. We've had numerous conversations about this. The fact that TCJS couldn't find the time to release him until he was dying, but they quickly released him as he was dying, and so now his death is not being counted by this commission as a custody death. This is one of the most egregious cases I have ever seen of over-detention and the most laughable excuse to not comply with the Sand of Land Act. I urge the Commission to take those rule recommendations seriously to prevent over-detention. These rules need the seriousness that taken, they deserve to be taken seriously. Because we've had people being released, charges dropped, Victoria Rogers, her uncle Victor Reynolds, Diana Bailey, 2 cases that we know of, and then of course this young man from Bear County Jail, who was over 1,000 days time served. I want you to think about his family as you think about those rules. Thank you.
Thank you. Jasla Griffin.
My name is Victoria Sarceda Barrera. I'm coming today on behalf of my husband, who's not yet dead, and she said I could come up for her.
And I can't let you, we've got to have you listed as
It's
the witness.
30 seconds. My husband is still alive, and you have the opportunity to help.
Yeah.
Please, please, I ask that you just listen to me for 30 seconds.
I've got to have you on the record.
Yes, you can go ahead.
Mayor?
Yes. I'm Joshua.
Okay.
My husband is incarcerated at Bear County Jail, has gone 2.5 weeks without his PTSD medication. And no matter how many times I call, no matter how many times I explain to them that he's already had his medication inside Bear County and they have his diagnosis on file, they refuse to give him this medication. And to add insult to injury, not only do they leave their inmates inside of the cell for 5 hours a day just to call it a shift change, it only creates more aggression. The only thing that I'm asking today is that my husband be afforded the opportunity to take his medicine after having been there for over 2 weeks. I only ask because he should not be there in the first place. Somebody dealing with a mental health condition like PTSD does not deserve to be in jail. He deserves to have help. And I'm only asking that you consider maybe one of you take 5 hours out of your day, sit in a bathroom stall with no TV, no radio, no communication with your family, and see how that feels. It's the only jail in the nation that makes them sit there for 5 hours for what's so-called a shift change, and then says, well, they're too aggressive to let them out. It's like if you put a dog in a cage, what would you expect for that dog to do when they're let out? All I'm asking is for you to save my husband before he ends up another statistic. Because to me, he's Jonas. To everybody else, and to Bear County, he's 970126. That doesn't mean that I love him any less.
Before I close out this public comment period, again, I want to remind everybody that as much as we want to hear from each and every one of you, we do have some required rules we've got to follow. And that is, if you wish to provide witness testimony, we need the individual providing the testimony to fill out the appropriate paperwork out front when you first get here. Also, again, I would ask that everybody maintain good order when we're having public comment. Don't mind the applause. Like I said, any other outburst outside of that is considered out of bounds. And on that note, I will close public comment. Move on to item number 5, old business. Item A, the Bear County Jail review of and possible action regarding notice of non-compliance and remedial. Director Armstrong.
Thank you, Chair Rose. Bear County is on the agenda this morning for review of their compliance status. They are currently in enhanced enforcement with a remedial order, and I believe the sheriff's here to speak on it.
Good morning, Sheriff, Mr. Director, members of the commission. Thank you so much for having us up. I'm Sheriff Javier Salazar, Bear County Sheriff's Office. I've got Assistant Chief Joel Jensen, Deputy Chief Don Peña, Sergeant Tammy Flores here, and as was mentioned, we are very much looking forward to hopefully passing our next comprehensive inspection and coming off that list of enhanced supervision. I'll open it to whatever questions you all might have.
I don't have any questions this time. I'd like to state that Bear County passed the first of its 2 comp inspections in February of 2026. So they're due for a second inspection, and our recommendation at this time would be to continue to monitor until that second inspection.
Right. All right. Thank you, Sheriff.
Thank you.
Item B, Harris County Jail review of and possible action regarding non-compliance and remedial order. Director Armstrong. I understand. Orson will be recusing himself.
Sheriff Rowe, the Harris County's on the agenda this morning for review of its compliance status. They are currently in enhanced enforcement, also with a remedial order in place. And the chief's here to speak on that.
Good morning, Chairman. Thank you, Director. Thank you, Commission, for continued guidance. We have recently, were recently inspected, an unannounced inspection, and I'm glad to say that we were in compliance. We appreciate the guidance y'all have given us over the past year, helping us lead our organization in the ways to innovate, find new ways to care for the inmates, take care of the facility. Chief Vasquez is here to give some more detailed information. We also have Harris Health Executive Director, P.P. Field, answering any of your questions. Any questions?
Questions from any Commissioner? Oh, go ahead.
Good morning. Thank you, Mr. Chairman. I want to just get caught up on a couple of items that we've discussed in the past. One of those being the number of inmates out of state. One of the things I wanted to see is the trend in terms of from quarter to quarter, what is the trend? Is it going up? Is it going down? For the last time we were here, we had a conversation, probably been 5 or 6 months now. So if you could go back and tell what that was then versus what it is now. Just roughly.
Good morning, Commissioner, Assistant Chief Philip Wilskis for the Sheriff's Office. Commissioner Locke, we made our first step in July of this year as a reduction. So we reduced outsourcing beds out of state by 100 at that time. We're tracking with the continued support from the Harris County Commissioner's Office, as well as our justice stakeholders working on population. So we're on track, and we believe that we will reduce by another 150 in this calendar year. So currently out of state, with the reduction that I just mentioned, that takes us down to 950 out of state at this time. So that's our trend for this year.
That's an improved trend.
And we put steps together for next year, again, with currently right now, 2 big steps to hopefully reduce that by another 400, concentrate on the out-of-state, as we've discussed. So those came out of the OLA facility, which is currently the furthest away facility.
Thank you.
Yes, sir.
It's a good trend. I would appreciate you continuing to update that as we meet quarterly, because that's been a primary interest and concern that we have that trend go down.
Yes, sir.
Now, another topic I want to discuss is on the medical side. We have had an interest for the commission to have a trend going, and the manner in which we discussed this, I won't go into the particulars, I think you remember what those are, as to the number of episodes, the medical episodes that required the tracking of inmates that needed to be transported into the hospital from the jail. Do you have those kinds of trend numbers?
I'll defer to Vice President Team.
Good morning, TCJS CEO for Correctional Health. So in reference to our transfers to the emergency room, over the last quarter, we're averaging approximately 260 transfers to ED. For the months of April, May, and June, we've had 0 delays in transfers related to not having an officer available for transfer. In previous quarters in December, initially, when this program started, we had approximately 34 delays the month of December 2025. Over the last 2 quarters, we've seen that trend down to, I mentioned, which is 0 at this time.
Okay, that's a good trend. What I do want to know, rather than get into particulars here, you're working with the staff to trend and track that?
Yes, sir.
So if I were to ask the staff for a graph or something that would display those trends by month, if I needed to or wanted to, they would have that.
Absolutely. Yes, sir.
That's good progress, and I think it's showing. Thank you.
Any other questions from the members? Dr. Armstrong?
As you know, Harris County has a agreed remedial order with us. We've been working with them on this to get them back in compliance. The inspectors were out there in July, real recent, and they passed that inspection, that comprehensive inspection. So they'll have another comprehensive inspection within 4 to 8, 10 months, and what the schedule looks like, and to see if they can pass that one to be moved off enhanced and possibly remove on the remedial order. So, do you have any updates? I know we had fire alarm system issues in the past. If you want to update us on that, right?
Yes, sir. Got the documentation, just want to review it, but we believe that the fire panel in the court system was finished last week. They finished up testing yesterday. And I just want to review it, but I believe we already have the letter in hand from the county fire marshal's office, as well as photos and dates that there are no longer any trouble issues in the court's fire panel.
And I know in the past you had another facility, you had a new panel put in.
We put a new panel in the 1307 facility, and then we upgraded the panel in the 701 facility.
With that, Harris County is currently in compliance, so no action needed at this point. Continue to monitor.
Thank you all.
We appreciate your time.
Item number C, Leon County Jail, review of and possible action regarding notice of non-compliance and remedial order. Dr. Armstrong?
Leon County is on the agenda today for non-compliance. They are in enforced enhancements, and they do have a remedial order present. They also passed a first comprehensive inspection in March of 26. They still need to pass one more inspection. Seems to be a trend in this meeting, which is good. So we'll hear from the representatives this time.
Alice Miller, I am the acting jail administrator at this time. I am here with my assistant Robert Kelly and my jail sergeant Mary Cabrera. We monitor every booking, every medical screening, every medical record that comes through. And I count my gentleman sergeant here for her assistance. She's done me a wonderful job in helping me in doing this transition. We're moving right along and looking forward to our next jail inspection to get this jail back in compliance like it's supposed to be. Any questions for me?
Any of the commission members have any questions for? No.
So at this time, like I said, they are in compliance and waiting to pass hopefully another second inspection. So at this time, we have no recommendations. Continue to monitor.
Thank you very much.
I do have one question. Do we still need to do the enhanced enforcement?
Yes.
Okay. Thank you so much.
Ready to pass the second inspection.
Okay, thank you.
Item D, Liberty County Jail, review of and possible action regarding non-compliance and remedial order.
Liberty County is here today to discuss their agreed remedial order. They are also in enhanced enforcements. The remedial order originally started in 2024, but we came to an agreed remedial order in May of 2026. I believe there's 2 outstanding things left on that agreed remedial order, which is the exhaust fans and training by the end of October 31st of 2026. So they're in the final phases of their facility, and they're here to give us an update on that.
Good morning, board members, Executive Director Armstrong. I'm Gunnar Sequist. I am counsel for Liberty County. I'm joined today by the Sheriff, Bobby Rader is with us, Heather, would you like to introduce your team? And we are here to give an update. As stated, we are moving through the compliance agreement. We've been able to provide an update to the commission to show that we are in fact compliant with the terms that we had agreed with the commission. The two outstanding matters, we are targeted to complete some recommended training by October. And we are also finishing the exhaust fan system that actually came up more recently. Those parts have been ordered, they've come in, that replacement is underway. I think we gave you the update last time, but just so I'm clear, we did get all clear on the fire control panel, and we did get our certification from the fire marshal as well. So moving forward, if there are any questions, we certainly have a team here to answer any questions.
Commissioners, any questions? Dr. Armstrong?
So, do we have a copy of that fire marshal's certification? Okay. Like I said, you have staff training still going on in the exhaust fans. They've done a good job of getting to where they're at. So the order talked about timelines and days for phase 4. Do you have a possible completion date of the exhaust fans and the training? I know the training is October 31st with the exhaust fans.
It was set around like end of August, beginning of October. We had one or two fans that didn't fit properly, so they had to reorder those. It is in a good direction. They had to get those in. They were a bit of a delay order. But that was the rough estimate for the company that is installing them, was late this month or early next month.
So once they're in, they'll be installed fairly quick. I mean, we're looking at September, October.
Yes, as they're installing them, they're also wiring them. Like some of the exhaust fans actually do work as of right now. So they are go. So by the end of the completion, everything should run properly. Also wiring them.
So, I mean, prior to November 30th, we would have everything.
Yes, current is end of next month or first part of October.
Great. Recommendation from staff is going to be to continue to work with Liberty County on the agreed remedial order. On completion, hopefully, we can come out and inspect the facility. Phase 4 is staff competency across all required operations and ongoing compliance with new investment.
All right, thank you all. Item E, Robertson County Jail review of and possible action regarding notice of non-compliance and remedial order.
Chair Rowe, the Robertson County is here today to discuss with us their enhanced enforcement and their remedial order. We're happy to say that they passed both of their comprehensive inspection. The most recent one was in July of 2026. They have been removed off of enhanced enforcement, and they have also sent us a letter requesting to lift the remedial order. So they are in compliance, and we'll hear from you.
Yes, thank you. We are in compliance. So we've gone through and added a lot of policy and procedure that was absent before, and it seems to be consistently staying where it needs to be with all the reforms and all the documentation that we're required to do. And I really appreciate the help that the commission has given us and the support that really helps a lot.
Any questions, Sheriff? Dr. Armstrong?
So at this time, with them being in compliance and then having passed both comprehensive inspections, the enhanced enforcement again has been removed, and they've sent us a letter requesting to remove the remedial order. Staff's recommendation would be to do that, to lift the remedial order from Robertson.
Commissioners, you've heard the executive director's recommendation. Do I have a motion on that? I have a motion. Do I have a second? I have a second. Any other discussion? Hearing none, I'll call for the question. All those in favor signify by saying aye. Aye. Any opposed? Motion carries. Congratulations. Great job. Thank you.
Thank you very much.
Item F, San Patricio County Jail review of and possible action regarding notice of non-compliance. Director Armstrong.
San Patricio is on the agenda today for non-compliance. They are in enhanced enforcement as of October of 2025. The remedial order was issued in May of 2026. They have passed their first comprehensive inspection of 2 in June of 2026, so they have another inspection to pass at this time. They're here to give us an update on whether they have to continue their compliance.
What was yours?
Good morning, Commissioners, Director Armstrong. We're continue working on our projects. We have done some great updates and continue to take pictures to our inspector to make sure that we are doing the best we can. One of the biggest problems we have is our roof leaking, and we've got some bids on that to get that repaired. And of course, we finally going through the process of building a new jail. Hopefully, it won't be 3 years. We're overdue.
Any questions from any of the commissioners? None? Director Armstrong.
So again, the San Patricio is in compliance at this time, needing their second comprehensive inspection, which will come at the appropriate time. So there's no action at this time. I request to continue the monitoring.
Very good. See you back here in November.
Yes, we appreciate that. Thank you.
That concludes old business. Item 6, new business, we have none. Item 7, discussion and possibly take action on county jail variances. Item 8, Galveston. Director Armstrong.
So Galveston County was on the agenda at the last meeting on this variance. The variance was approved for 6 months, but they're back at the 3-month mark to give us an update. I believe at that time, we were told they could possibly be looking into installing toilets and showers so they wouldn't have to have a variance on the area they're looking at, and they're here to give us an update on where they're at.
Hey, good morning. My name is Tyler Drummond, I'm Chief of Staff, Galveston County, and Captain Hall over the jail operations. Here this morning to respectfully request the commission to extend their variance and to grant us relief and not require the installation of toilets and showers. So we're looking at, based on the estimation that we had with staff, cost, I think we $400,000 due to that, how it would have to go through concrete and other that sets the price that's good back. Most importantly, the reason why we're asking that request is we're going through the study phase right now to assess the cost for jail expansion, which we're planning as a grant to put on the ballot in May of 2027. That's just how addressing the jail capacity facility was built, put online in 2006. It was built to kind of extend out in pods. So, just to complete the process where we're at.
Any questions from any commissioners?
Sure, just one question. And I don't know if you might have this information or not, but any healthcare issues related to the additional 36 beds that is part of this area?
Yeah, I'll let Captain Hall address the usage and limited use of care.
Yeah, sure. In regards to your question, you're saying there's medical issues in regards
Yes,
to those?
No events related to 36 additional beds.
What's that?
No events related.
No,
to
no, no,
this
sorry.
additional
No events in regards to that. We have them in 4 separate pods, and there's 8 additional beds in 2 of them, and 10 additional beds in the other 2. And the ones in the E&I pod are rarely used, but the ones that have the 10 additional beds, we use them here and there a little bit for overflow, but normally we get pretty much out of there within a day or 2.
Thank
you. Mr. Chairman, I do have a couple questions. I'm just making sure I got this picture right. So you're asking for 36 additional beds, and you wanting a waiver on not installing toilets or showers?
I think based on the cost and the interruption to services in the facility already with limited space, then having to relocate folks during that construction, and also based on the fact that we're pursuing looking at expanding, putting sizable investment expanding the capacity of the jail.
So help me understand, is it, you're asking the waiver because it's cost prohibitive or it's not legal?
Cost prohibitive at this time.
But it is legal.
Based on your standards, but I believe that's the recommendation of the commission, correct?
Commissioner, like if I may?
Well, definitely, help me get there.
Yeah, and I think there's the, miscommunication here. The reason this is a variance
We hate the facility, just a laundry group. So what makes it a dairy? They're not, they're not, and but they're asking today, and the 36 beds have been in existence for the last 3 months.
So this, not going to interrupt for a second, this was a renewal of a previous variance that they had asked for, and when we renewed it, we discussed the renewal of the variance and that they no longer have to have a variance for the congregation of over 48 inmates because that changed in our administrative rules. There's no longer a need for that variance, but the variance for the toilet and showers was still there. So they're just shy on the amount of toilets and showers that they have to have per the inmates in the area. So we continued the variance for 6 months. So the variance is in place right now. And at that time, we were told they would consider looking at installing toilets and showers in the area. That way they don't have to do a variance anymore. Now they've come back with an update that it's cost prohibitive.
I'm getting, I got a better picture now. What threw me off was not doing the customer cost. And so now I get it. It's all we do. Okay.
I just have a quick question. Has there been any concerns with plumbing with this variance? Any additional inmates?
Has there been any problems with
Plumbing concern?
like this, get the
No, with the ones that you have, that you had in your plumbing.
At this point, it's Galveston County's position is that this variance will probably have to stay in place until we potentially look at going out for an expansion.
Yeah, we respectfully request you continue variance, and if you want to have us come back to it, or not, very good.
Mr. Armstrong?
Okay. So you said this is going on the ballot in May, is that correct?
As of right now, the expectation is we call a bond election in May of 2027. For this facility, we also have a need in the juvenile justice detention facility.
So the variance is active right now for another 3 months. So my recommendation, or the staff's recommendation at this time is going to be to leave the variance in place for the next 3 months. And have them come back with a report as to any plumbing issues, any issues with violence in the cell, any conflict issues, whatever issues you may have in those areas. Report back on that in 3 months, and at that point, we'll decide if it should be extended for a certain period of time until you're.
Nothing sexy about voting bonds for jail expansion. So what's plan B if bond doesn't pass?
Depending on what the pricing comes back with for the expansion, right, the additional funds, Commissioner's Court will have to assess other options. But I don't know if that costs 10, 20, 30, 40, 50, right? So I think we can have other such people assess that.
I guess though, but if commissioners don't pony up and help with money, then do we as a commission keep extending this variance 3 months at a time for however long?
That's up to the staff here, correct? And it would depend on your population and where they're at as well. They're within their population at this time. Are you using the beds at this time?
Yeah, we'll use them temporarily, but then they'll get out pretty quick.
So if you didn't have them, you'd be in non-compliance right now.
Mainly also because of the tourism industry down there in the county, right? So over the past few months with the tourists down in Galveston Island, that causes the kind of flux that we see in the jail rate, which is why they are temporarily within a 24-hour period using this capacity. And don't let that happen.
All right, so no action required. You're still in compliance. So we will visit back with y'all in 90 days at the conclusion of this current variance. And we'll, as Director Armstrong said, we'll see how things have been going at that point, consider extending it at that time. Very good, thank you. Thank you. All right, item number 8, receive updates, discuss, and possibly take action regarding the Administrative Rules Advisory Committee. Item A, rules for adoption. Director Armstrong.
So these are the rules that have been published to the Texas Registry. After the last meeting, they have come back with no comments, and they are ready for adoption. So the 259.132 is the exercise areas, and the language just changed to try to make it easier to understand. The actual requirements of that standard did not change. The sizes and the requirements within 253.1 definitions is where we get into the guardianship rules. Goes to number 14, guardianship database query, and it defines that the database is maintained by the Office of Court Administration. And then 15, guardians defined by the Texas Estates Code. Number 16 talks about the ward, the definition of a ward. And then number 17 is the letters of guardianship, the definition in the state's code. And then the rest of them is just number changes to get everything in line in that standard. The next standard is 251.6, complaints. Again, it's about guardianship. Number 1, it talks about upon receipt of the order appointed guardian, a guardian shall be given an inmate handbook. 265.4 talks about inmate files. The information contained in the guardianship database query. GDQ, returned in the Government Code 155.153. It describes everything that the Government Code 155.153 talks about. Again, all these you reviewed last time is sent for public comment. There was no public comment. And then there's some number changes on that as well to get all the numbers in line in that administrative code. 65.5 health tags adds the word for a guardian and adds in writing on retention of health personnel and supervisors on duty. 265.7 telephone use adds for inmates with a guardian, the jail shall attempt to facilitate and communicate with the guardian. We are asking to hold 267.7 release of ward with no action. This needs to come back to the Administrative Rules Committee and be worked on, and also worked on with legislatures. There's a direct conflict with laws on who a guardian can be released to. You have to be released to a ward, but if a ward is unavailable and not able to be contacted on a weekend, the jail still needs to release them to somebody. So we have been in contact with the Governor's Committee on Persons with Disabilities and working with them on getting the legislatures to update the laws to help us facilitate the release of guardians. So again, we asked to hold 267.7. And 273.2 is a health service plan. It goes over to number 16, provide procedures for a guardian or the person who has medical decision-making authority to have access to the ward's medical file. The new rule 273.9, guardianship, discusses order appointing guardians shall be obtained for review of what powers or authority the guardian obtains and what if any rights are retained by the ward. Said orders shall be obtained by the jail staff and the court with jurisdiction over the guardianship or from the guardian. It goes on to talk about consent, medical, medical histories, decision-making for medical, and access to medical records. And 281.5 is staff supervision. It is not part of the guardianship. It is a food manager's license. The administrative code changed in that section, and we had to update our rules and our laws to have a food service manager on site when food is being prepared all the time. So these are all the rules that have gone through public comment, come back with no comment, and are ready to be adopted.
If there's any questions?
I have a question when it comes to the guardians, the release of the ward or the guardianship move. Has there been any conversation about having a guardian ad litem available that when these folks do need to be released to somebody that has oversight or authority? Is
So
that something that's considered?
That's part of the, I believe, concern is the court has to think that, right? And so, because what we were told is, if a ward is being released, we have to listen to the guardian. If the guardian's not available, we have to contact the court. So our problem again is there on weekends, holidays, so forth. This happens. It's hard to get a hold of people in the court.
I don't know about research, but does the court or can the court be given the authority to appoint the guardian ad litem?
I'm not sure.
At this moment,
We will too.
after hours.
Any other questions for Director Armstrong? So with,
What you doing?
all right, so you've heard the executive director's presentation. I would accept the motion to adopt 259.132 exercise areas, 253.1 definitions, 216.6 complaints, 265.4 inmate files, 265.5 health tags, 265.7 telephone use, 273.2 health service plan, 273.9 guardianship, and 281.5 staff supervision. I have a motion to adopt. I have a motion. Do I have a second? I have a second. Any other discussion? Hearing none, I'll call for the question. All those in favor signify by saying aye.
Aye.
Aye. Any opposed? Motion carries. Item B, rules for public comment, 291.2 inmate correspondence plan. Mr. Armstrong?
So this came out of the Administrative Rules Committee as well, 291.2 inmate correspondence plan, and just updating it to include electronic correspondence. That's the only wording that's added to this area here, and we're just asking it to be sent to TCJS for public comments, update the school.
You heard the executive director. I'd accept the motion to move 291.2 inmate correspondence plan to the public record, or the Texas Registry for Public Comment. I have a motion. Do I have a second? I have a second. Any other discussion? Hearing none, I will call for the question. All those in favor signify by saying aye. Aye. Any opposed? Motion carries. Item C, public petition for change to minimum jail standards. Dr. Armstrong?
So we have the first three. We have Amira Davis, Paula Keith, and Leroy Jones, I believe. And they're all public petitions about over detention. Trying to remember. They've been sent to the ARAC committee. Our Administrative Rules Committee was unable to meet this quarter. And so they'll be talked about more in the next meeting. The over detention that it's talking about is impacts DCJ, and is being held over detention in TCJ time. And some of the comments, the public comments here for comment for rule adoption is wanting the jail commission to get involved with some of this time calculating when they should be released. under statute, it's under, falls under Government Code 499 and Code Criminal Procedures, Chapter 42, which is directly related to TCJS requirements. If we don't have access to that information, it doesn't really fall under Article 3 to calculate TDC. There is questions about impacts and things such as that. Who sends them, who gathers this information and sends it to TDCJ. And, I did meet with TDCJ a couple of weeks ago, and they have gone to an electronic portal system. And they're averaging 28 days now on their impact. So I'm hoping this will help some with this. But yeah, our recommendation at this time is to send this back to ARAC, let them finish working on it and make a determination on what to do with this one. No, because it's already been sent to the ARAC, but they don't have any more, so. The next one is medical. And it talks about, it's a health concern with women's underwear. And we read it last time. Basically, it's stating that, so jail standards does not require underwear to be provided to inmates. And this petition is from a medical student in one of the jails that's helping and working in the jail. And she states that women need underwear for different health reasons. So we actually met with 3 different subject matter experts that are in the correctional field. So providers that work in jails. And one was a female and 2 males. We walked through this and talked through it. And they did come back and state that the rule change for women's undergarments, they did not see a public health concern with that. But they didn't say they didn't think women needed underwear. They said that's a possible recommendation for review to look into to provide underwear because of just the humanity and the moral standards of not having it. And then you have the issue of the menstrual cycle as well during that time, which you would have to provide underwear if you use pads and stuff like that. So our recommendation on this is to let's send this back to ARAC to look at if the board wants to issue a new rule to where underwear shall be provided, whether it be men or women. So with that, we also followed up on a study that Judge Stout asked us for the cost. And I believe that's a supplement in the packets. And we also did a survey of what the jails are providing right now that we put in that packet as well. So you have that in the packet. We'll take that to ARAC as well. If you'll let this go back to the Administrative Rule Committee to be reviewed. But all that information's in the supplemental packet that Judge Stout asked for.
So they've already got it now. Send it back to a new, he's a new public.
So it's, they've had it, and we were asked to bring this information back to Judge Powell in the last meeting. But our recommendation is to take no action on the health concern, because that's what the subject matter experts recommended, that it was not a public health concern, but they do recommend to look at possibly issuing underwear for the mental side of things.
So no action is necessary because
It's already in the committee, so we can just send it back to work.
And the reason I was asking about costs, I mean, at some point, somebody's going to pay, and I don't think the cost should be the deterrent. The health is the focus that we're on. But we just don't want any surprises as we move down the road. But I'm in budget process right now. So I need to make sure that if a change occurs, that we have money provided for the jails to take care of the business at hand.
So the next one is Lydia Leo's proposed change to standard. The health operator Plan shall provide procedures for contacting and providing medical updates to the next of kin for patients who have been hospitalized for more than 7 days, are admitted to an intensive care unit or cardiac care unit, are undergoing general anesthesia, are entered in hospice or into life care, are on life support, or deceased. So they're asking for award to be for family next of kin contact. So we have, this is a new one that came to us in June. And we have put some wording together, staff has, so we're asking for this to be sent to the Administrative Rules Committee for review and recommendations. We clean up the language that we've put together, make sure they're all good with it. We met with the Sheriff Association of Texas yesterday, and they have also provided some wording as well. So we'd like the Administrative Rules Committee to put those two together and see what come back with.
Commissioners, do you have any other questions for Director Armstrong?
Mr. If this, I'm gonna go back to the previous, if you don't mind, with the underwear discussion, because that's what was the question. So let me make sure I understand. So, is it conceivable that a person could be incarcerated for 1 year